Good morning. I'm J.J. Prescott. I teach at the University of Michigan Law School. I want to thank John Jay and Jason for having me here. I'm just going to talk. We haven't been given very much time, so I'm going to try to cut quickly and focus on the impact of what we've been doing in Michigan and are starting to do in other places on citizens. So first, let me tell you what we've been working on. I need to speak in here better? All right. Let's see if this, sorry. It's the burden of being tall, I guess. Essentially, 5 years ago or so, I started working with a former student in hopes of helping Americans resolve outstanding minor warrants. As we discovered in the last year or so, this is a real difficulty in many cities. And actually, a lot of it comes down to just the physical infrastructure. In order to resolve a minor outstanding warrant, you have to essentially self-surrender by walking into a court and putting yourself in jeopardy. So we wanted to essentially use online technology to allow people to begin conversations with the court, with prosecutors, with judges, and resolve those outstanding issues. So clearly challenged in this area. So what we've done in Michigan is essentially allow a platform that allows people in courts to speak with citizens who have issues in courts. We began with warrants. That was our initial goal. We're doing that in a lot of places. Courts found it useful to have this sort of technology to resolve civil infractions. So now a lot of informal and pre-formal hearings are occurring online. And in the last year or so, we've expanded to deal with a number of other types of disputes that exist and that are resolved in courts or with other criminal justice actors. We've had a lot of momentum in the last, month or two. We've added 3 or 4 new courts that are using this kind of technology. But what I want to focus on is how, or what we know, not just about how this helps courts, but how this affects citizens and their use of the courts in this way. So first, let me give you a very quick run through of how this works. Essentially, it's not surprising. It's not rocket science. A person who has an issue, in this case, let's do a traffic ticket or a warrant, an outstanding warrant. They essentially search online. Our system taps into a state-level database and also into court-level databases and identifies the issue. Once their results are found, those results are often screened or triaged based on decisions that individual judges and courts make. We don't make any of those decisions. They decide which kinds of cases they want to resolve in this way. If there is a case or an issue that you have to resolve with the courts, you can begin that process. The process is that the system is designed to be very configurable. So. Depends on the type of case, and it depends on the court and even potentially the particular judge. In this case, for a traffic ticket review, it's fairly straightforward. Some courts might want to know whether or not if they offer you some kind of plea bargain, whether you'd be willing to go to traffic school. For an outstanding warrant, it's obviously more difficult. Typically, you have to explain why you missed your court date, or if you owe money, why you haven't been able to pay, why you haven't resolved it before now, and what you can afford to pay going forward. Once that information has been collected, essentially the other actors become involved, and they have their own dashboards and are able to choose to either make an offer. Maybe they decide, for example, that this online setting isn't appropriate for this particular case and the person ought to be coming in to speak with them. But in any event, either some sort of resolution occurs or there's a decision not to resolve the case in this way. And of course, it ultimately goes back to the defendant or the litigant and asks them whether or not the proposed resolution, if there is one, is acceptable. Okay? So what are the potential issues here? And I'm committed to keeping this talk very short, so let's see if I can do it. An obvious one is the digital divide question. So we've approached that in a couple of ways. First, when we have talked with courts about using this platform, we pitch it and defend it as essentially an additional way of accessing the courts. So litigants don't lose any options, so they can continue to use all of the traditional ways of dealing with outstanding issues. But for those who have real trouble making use of those traditional options, where the brick and mortar business hours approach to solving problems doesn't work very well, this should really, in our view, and seems to have, when I talk about some of the data, seems to have made a difference in people's ability to get their problems solved. But nevertheless, maybe it's unfair if we make this sort of technology available, maybe we're essentially already helping those who have a lot of resources. And I can't say that, I mean, there's got to be some truth to that, but we do know that the digital divide is quickly closing. I'd say 50% of the people who access courts in this way do so through their telephone. And it seems increasingly to be the case that people will have a telephone before they'll be well fed and have a place to live. These numbers suggest that even in the last few years, the digital divide is really shrinking quickly, so hopefully that won't be a big issue in the long run. The other real driver behind this, as I mentioned, is the challenge that individuals have getting to court. So there are a bunch of different kinds of challenges. If you're a wage worker, you got to miss work. If you want to go in, I don't know how many of you have gone in to deal with a traffic ticket, maybe to have an informal hearing, to have 2 points removed off your license so you don't have much higher insurance payments. Well, of course, I'm a law professor. I can do that. I can take the day off work at no financial sacrifice. But if I worked for wages, it might cost me $50 or $100 to do that, which is a pretty regressive system. So there are lost wages challenges. There are consequences from missing work, cost of childcare, transportation out-of-pocket expenses. Geographic barriers also matter. So this is less true in an urban environment, but in rural settings, courts can be an hour or more away, which obviously makes it really difficult if you have to return to court a couple of times. And finally, there are the psychological difficulties, and I'll say something about this later. But going to court is never very fun, and that's even true for a lawyer. Going to court when you don't know how the law works, you don't understand the process, and actually you don't like public speaking. Even if you have something you want to say, to get up in front of 50 people and talk about it is difficult. All right, so what have we found? So I'm going to just present some findings that I think are relevant to this question about the effects on citizens. So first of all, this is one of our courts. Prior to the use of the platform, we had a bunch of people who would schedule, 47% who would schedule informal hearings. Note two things after we installed the system. First, more people overall access the court. Right? So, between 5 and 10% more people in this particular court started using either Matterhorn or their other options to come in and talk, understand the charge, maybe even have a more individualized, better outcome. But on top of that, a lot of them were able to do so at less cost. Okay, so a lot of them did it online, much easier. 37% of our respondents in a survey we did said they would not have been able to come into court in person. So when you start thinking about the source of warrants, you realize, oh, I'm already out of time, I failed. When you start thinking about what the source of warrants, you realize actually a lot of people, they miss court dates or they don't pay because they just can't get it done in time, or they don't have the ability to get there during business hours. So we actually have some explanations that have come through the system up here. So I recently started a new job, and for the first 4 weeks of training, I couldn't miss any days. Or, quote, I am scared to come to court because I don't want to be arrested. My children need me, the vehicle I was driving. So these are for tickets. This one's actually for a warrant. The vehicle I was driving was my ex-husband's. We got pulled over, using it to transport 2 of my children to the doctor. I will do anything not to go to jail. Please, I have 2 warrants. So this is a person who is, taking a totally reasonable, in my view, approach to having an outstanding warrant that they cannot resolve. They don't have the money to resolve. They're just ignoring it because there's no other real solution other than potentially putting themselves at jeopardy of losing their children. All right, so here's another case study, and this may be a little harder to read. It's mostly about the time saved both by litigants and by the courts. For citizens, to the extent that, I've lots of stories about people who have outstanding issues that take months and months and months to resolve. They reschedule hearings. Here we see that where or people are using Matterhorn, in those courts, we wind up resolving cases much quicker, which is not only good for courts, but it's good for people too. We have less default in cases, so when people resolve their issues in this way, they tend to understand what they need to do and do a better job at getting it done. And lastly, I'll say something about voice. So you know, it's not surprising to me in retrospect that being able to carefully think about what you want to tell to a judge and essentially write up some text that explains your position might be more pleasant and a more effective vehicle to describing your situation than standing in front of 50 people and a judge who is sort of raised up above you, or speaking to a prosecutor in a fairly intense, stressful situation where the prosecutor's like, come on, come on, come on, I got 15 people waiting outside. You got to tell me what you want to tell me. And so we haven't had a great way of evaluating this, except that a lot of people give really thoughtful, well thought out, heartfelt explanations asking for whatever it is they're asking the court to do. So I'll stop there. Thanks very much, and sorry for going over time.